Welcome to class, students. Settle down and sit up straight. Have your notebooks ready, because today we're diving into a highly critical explainer for your upcoming contract law examinations. We are going to master the exact structure you need to score maximum marks on the Contract of Indemnity. Today, we aren't just passively reading the law. No, we are dissecting it precisely as a KSLU evaluator expects to see it presented on your answer script. Our focus areas are Section 124, covering the definition, the nature and scope of the contract, the landmarked Gajanan Moreshwar case, the rights of the indemnity holder, and finally, the commencement of liability. Now, before you write a single paragraph in your KSLU exam, you absolutely must provide the evaluator with a clear synopsis, exactly like this structured breakdown, to instantly demonstrate your command of the subject. Moving to our first major heading, Section 124, the definition. We always begin with the absolute statutory baseline. Section 124, I want you to heavily underline this specific section number on your paper. KSLU evaluators are actively scanning your script for Section 124 of the Indian Contract Act, 1872, as the foundational anchor for any indemnity question. If you miss this number, you immediately lose the examiner's confidence, and we certainly do not want that. The section states, a contract by which one party promises to save the other from loss caused by the conduct of the promisor or by the conduct of any other person. Listen to me very carefully. You must read and reproduce this verbatim from your Bear Act. Do not paraphrase a single word. The exact phrasing regarding the conduct of the promisor or any other person is entirely non-negotiable if you want full marks. Why? Because this highlights the strict human agency requirement in Indian law. We don't include events like fires or natural disasters under this specific definition. Those fall under contingent contracts like insurance. Let's break down the parties. We have the indemnifier, the person who promises to compensate, and the indemnity holder, the person who is protected. When writing your exam, explicitly separate these two parties on your sheet. Make it crystal clear to the examiner that you fully grasp the bilateral nature of the parties involved. Next heading, nature and scope. Let's systematically break down the nature and scope of the contract into distinct, highly readable bullet points. First, the nature of the contract. It is contingent, meaning it depends entirely on a loss occurring. It is bilateral, involving two parties. It can be express or implied, arising by clear agreement or by conduct. It explicitly covers loss. And finally, it has a narrow Indian definition, restricted to human agency only. Now, you should space these out with precise subheadings in your exam presentation. When you write about the narrow Indian definition, make sure to specifically note that unlike English law, which includes implied promises and non-human events, the Indian Contract Act strictly restricts indemnity to losses caused by human conduct. Now, for the scope of the contract. 1. Protection against loss, ensuring financial safety. 2. Commercial importance, heavily utilized in insurance, agency, and general business. 3. Expanded judicial interpretation. Look, while the statutory definition is narrow, its scope in actual legal practice is massive. Remind your evaluators that mentioning expanded judicial interpretation creates the absolute perfect, logical transition to the landmark case laws that shaped modern Indian contract law. Which brings us to our landmark case, Gajanan Moreshwar. Right here, students, is where you separate a standard 10-mark answer from a top-tier 16-mark answer. You must deliberately pause your analysis and dedicate a distinct, boxed section on your paper to this landmark case. Step 1. The context. Expanding the scope far beyond Section 124. Step 2. The holding. Establishing that the indemnifier holder can compel the indemnifier to save him from liability even before actual loss occurs. Step 3. Relevance. It solidly establishes equitable protection. Now, I want you to draw a literal box around the citation Gajanan Moreshwar v. Moreshwar Madan on your answer sheet. You must briefly state the facts. The plaintiff was facing a lawsuit regarding a mortgage liability incurred entirely at the defendant's request. The defendant argued he shouldn't have to pay a single rupee until the plaintiff actually suffered a financial loss. But the ratio decidendi, the final holding of the court, crucially rejected this argument. The court ruled that if liability has become absolute, the indemnifier can compel the indemnifier to pay off the claim before the holder is financially ruined. The absolute relevance of this? It brilliantly imported English equitable principles into India, drastically expanding the rigid, narrow language of Section 124. All right, next section, rights of the indemnity holder. Once you have established the definition and scope, you must immediately transition to the specific statutory protections granted to the protected party. Section 125. Use a bold, prominent heading for Section 125. Doing this signals directly to the evaluator that you've successfully moved from the definition phase into the operational rights phase of the contract. Let's look at the rights under Section 125. 1. Damages. This covers all damages he is compelled to pay in a suit. 2. Costs. This means all costs incurred in defending the suit provided he acted prudently and within his authority. 3. Sums paid in compromise. This covers the amount paid in settlement, if made in good faith and not against the indemnifier's express instructions. I want you to take your pen and underline those conditional clauses. Acted prudently and made in good faith are mandatory, non-negotiable keywords. The examiner will be actively hunting for them to ensure you understand that these rights are not an absolute blank check, but are strictly governed by reasonable lawful conduct. Step 1. Case context. Acting under authority. Step 2. The holding. Adamson v. Jarvis held that a person acting under authority is entitled to be indemnified for all lawful acts done. Step 3. Relevance. It solidifies Section 125 cost and damages recovery. Direct your pen to underline Adamson v. Jarvis heavily. You must briefly explain the background facts here. An auctioneer sold cattle purely on the instructions of the defendant, but it turned out the defendant did not actually own the cattle, and the true owner successfully sued the auctioneer. The ratio decidendi of the court was that, since the auctioneer acted lawfully upon the instructions of the defendant must absolutely indemnify him for the damages paid to the true owner. The relevance here is profound. It demonstrates exactly how lawful authority automatically triggers the right to be indemnified under Section 125. Moving to our final major heading, Commencement of Liability. We now arrive at the crowning segment of your masterclass conclusion. You must address the ultimate legal question: when does this liability actually kick in? We have column 1, the traditional view, where liability arises only after actual loss is suffered, and column 2, the modern equitable view, where liability arises when the holder's liability becomes absolute, even before payment. I highly recommend you draw this exact comparative table on your exam paper. It rigidly contrasts the outdated English common law view, where you literally had to go bankrupt paying a claim before you could ask for indemnity, against the modern equitable view. And make sure to explicitly cite Gajanan Moreshwar one final time right beneath this table. This proves your complete mastery over the timeline of liability. It shows the evaluator you comprehend how the law evolved to become a true proactive shield for the indemnity holder. So, I leave you with this. Since the courts broadened a narrow statutory definition to promote justice, does the modern equitable view mean an indemnifier's liability is now virtually absolute the moment a threat appears? Conclude your paper by asking this provocative question. Leave the evaluator with this compelling thought, demonstrating that you don't just blindly memorize statutes, but you truly understand how judicial equity transformed a rigid, narrow commercial statute under Section 124 into a highly dynamic protective legal mechanism. Structure your answers exactly like we discussed today. Apply these exact authorities and you will absolutely dominate your KSLU contract law exam. Class dismissed.